एक बार 2012 में कोई सेटलमेंट तो हो गया था आपका, साथ में रहने के लिए आपने एग्री किया था?
नहीं सर, मैंने अग्री नहीं करा था, कस्टडी केस मेरे पास था. It's been 17 years we are not living together.
It is a case of custody of the child.
Yeah, custody child जो मेरे पास है अभी divorce का केस का है. It's been 17 years.
Plurality का था.
This is an appeal that has been filed under Section of the Family Court Act, in which application for mutual consent of divorce was dismissed by the Family Court, Your Lordship. And since 2009, this appeal has been pending, Your Lordship. And at the last date of hearing, the court directed the appellants to be present to hear the matter from them. They have been living in separation since more than 15 years, Your Lordship. And my appellant is only upbringing the child on her own. Therefore,
this is the case of divorce.
Yes, Your Lordship.
Your application has been rejected.
Yes, Your Lordship.
By the trial court.
Yes, Your Lordship. A list of date has also been prepared.
So the respondent is not appearing.
Well, he is not appearing since 2000. In November 22, when the application was filed for urgent hearing. Since then, he is not appearing, my lord. And the parties are living separately since March 2006, my lord. So there are no chances even of mediation and all that. That has failed before the trial family court as well as before this honorable court. Initially, an application for this with consent was filed.
Application was filed on the ground of cruelty.
Yes, my lord. And the cruelty was three-phased: misbehavior in drunken state, repeated demand of money for business, and in fact 7 lakhs were provided which he did not open business and spend upon himself, physical assault to the wife, and then in drunken state waking up the child in late hours on the pretext of playing with him. And the trial court, family court, has non-suited me on 3 grounds, my lord, which are in para 10 to 10, 11, 13 and 14 of the impugned order. In para 10, the trial court says that there is variance in the statements made in the notice and application as regarding his being in drunken state and that. In para 12, para 11, the trial court says that it has not been explained as to on which date the girl has come back to the matrimonial home and again went. So this story is unbelievable because the dates are not mentioned. And then, my lord, in para 12, it has been said that
ये भी नहीं माना जा सकता कि प्रार्थी बार-बार प्रार्थी को प्रताड़ित करता.
जी, in para 11 it has been said merely on the basis कि प्रार्थी ने यह भी नहीं बताया कि प्रार्थी के व्यवहार के कारण वह अंतिम बार प्रार्थी का घर छोड़ने के पहले तब तक वापस आई थी और प्रार्थी उसके पिता के अनुरोध पर वापस आई थी. इसलिए ये नहीं माना जा सकता कि प्रार्थी बार-बार प्रार्थी को प्रताड़ित करता है. Non-mentioning of a dates will not be relevant, my lord. 5 years they have lived together, in which if 4 times she has come back, she have mentioned 4 times I have come back, an interval of 5-6 months each time. The dates it's not really possible to remember those dates, my lord. Then, my lord, in para 13, it has been said that they are meeting at regular intervals. Para 13 is the ground that they are meeting at regular intervals, my lord. To which, in evidence, it has been given explanation that for the benefit of the children, they were meeting at the regular intervals. And then, my lord, lastly, at para 14, the amount of 7 lakhs given to him has been displayed by saying that income tax returns have not been filed. It was stated that was given in cash. So there was no occasion to file the income tax returns, my lord. And my lord, from the evidence of the husband, respondent itself, it is crystal clear that there are no chances of reconciliation, my lord. I draw my lord's kind attention toward the statement of husband Ankur Bhatnagar, my lord. in examination in chief itself, in para 3 is stated, फिजा करीब 2.5 साल से मुझसे अलग रह रही है. जब से फिजा मुझसे अलग रह रही है तब से करीब करीब हर 2-3 दिन में मेरी उससे मुलाकात होती है. Then without para 4, सैवितागंज, दिस इज क्रॉस एग्जामिनेशन नाउ. सैवितागंज थाने में तलाक के लिए दबाव डालने के संबंध में मैंने पुलिस अधीक्षक इंदौर को 2 बार आवेदन पत्र पेश किया. उसकी तारीख, माह और सन मुझे याद नहीं है. मैं अंदाज से नहीं बता सकता कि इस घटना के कितने दिन बाद मैंने पुलिस अधीक्षक को आवेदन दिया. मैंने न्यायालय में इस आवेदन पत्र की प्रतिलिपि पेश नहीं की है. मैं इसका कोई कारण नहीं बता सकता हूँ. यह कहना गलत है कि मैंने अपने आवेदन पत्र नहीं दिया और आज झूठा कथन कर रहा हूँ. This is for the mutual consent. He says that he was pressurized. He has not given any complaint to the police in that regard. Now para 5. फिजा का स्वभाव कुछ कुछ बचपन का है. फिजा अभी भी किसी भी बात पर उतर जाती है. वह कुछ कुछ अड़ियल स्वभाव की है. फिजा उच्च विचारों वाली महिला नहीं है. फिजा ने मुझे ब्लैकमेल करने की कोशिश की है. फिजा के शौक महंगे हैं. फिजा मेरे माता पिता की उपेक्षा करती है. इन सब के बावजूद मैं फिजा को अपने साथ रखना चाहता हूँ. एंड सो ऑन एंड सो ऑन. So, in fact, he is also not satisfied.
तो इसमें 13B की भी एप्लीकेशन पेश की थी आप?
After that, once the mutual consent was, it is not appeared, so it was dismissed, my lord. Then 13B was filed on 18/7/2007, my lord. Item number 6 of the list of dates. On the grounds of cruelty, it was filed. 13B was initially filed. 13B, I am sorry, I stand corrected. 13B was filed on 26/6/2006, my lord.
इसका क्या हुआ? इस एप्लीकेशन का क्या हुआ?
Kindly see item number 5, my lord, 19/2/2007. As the respondent expressed his unwillingness to get divorced by mutual consent, the parties did not appear before the learned family court, and the said application seeking divorce by mutual consent got dismissed. And then on cruelty it was filed. When it was dismissed that I am not allowing daughter to meet him, I approached this honorable court. This honorable court said on technical grounds you cannot dismiss it, re-decide it on merits. Then they decided it on merits, and I am before my lord.
17 तो अलग ही रहता है. तो अलग अभी नहीं रहता. डिसाइड तो करनी है. कुछ तो करा के का भी ग्राउंड बन जाता है.
Yes, my lord, because since 2006 they are living separately.
नहीं, see, we have to decide है ना. वो आए या ना आए, we have to decide it.
Yes, my lord.
Any citations, any submissions we want to make further?
Lord, by submission, this, Lord, I say that though irreparable breakdown of marriage is not a ground for divorce prescribed under it, but the Supreme Court exercising power under Article 142 have said, so some inferences can be drawn from those judgments also, my lord. Although I do not say that this honorable court can exercise the powers under Article 142, but I say inferences from those judgments can also be drawn. And here is a case, my lord, wherein this is that judgment, my lord. Here is the case, my lord, wherein the parties are living separately since 2006, my lord. And looking to the age also of the girl, if she wants to remarry, probably if this is not decided, then she may even be not of marriageable age, my lord. She was 28 years on 2009, my lord. So she must be 38 by now. But for our
After 2012, none appeared for the respondent.
yes, my lord.
In this case.
Yes, my lord. After 2014, my lord, I will say, this was admitted it was adjourned. Yes, my lord. After 2014, and para 6 to 8 of this judgment is about irreparable breakdown of the marriage, my lord. This is Article 141, my lord. But here, again from 2006, there are no chances. So why the matrimonial tide be carried out when there are no chances of reconciliation, my lord? Because if within 2006 they are living separately, it is within 16 years if they could not reconcile their difference, then in future also most probably they won't be able to do it, my lord. And then the grounds of cruelty have been non-suited on technical grounds. 7 lakhs you have given to him, you have not filed income tax returns. That was in cash. Then variance in the statement in the notice and that, non giving the dates when you have left matrimonial house and when came back. It's not a criminal case which has to be decided on the exact evidence. It has to be decided on touchstone of probabilities. For that, the basic foundation was laid, my lord. And in evidence abuse, all the parties have said they don't want to they don't want to live together.
ठीक है. Like